Great. We've got our interpreters here. Johnny, thanks again for being with us today and sticking with us for this whole event. My name is Brian Silva. I am the founder and executive director of NEAT, the National Quality Action Team. And starting with when we were Marriage Equality USA, we've been doing these events for quite a few years around LGBTQ related court cases. Thank you so much for being here. Before we go too much farther along, I'm going to ask Liz to bring up our slide to show folks who would like to hear this in real-time Spanish translation. We'll pop that back up onto the screen. Para traducción simultánea al España, marque 312-626-6799. Great. Thank you very much. So we're very excited to have you here at this town hall. I want to thank our ASL interpreters, LaShonda and Johnny, who've been with us since the rally earlier. This town hall is brought to you by the Decision Day Coalition, which is almost 100 organizations who have been working to put these events together for you today. So I'd like to take just a moment and bring their logos up on screen and give them a big shout out, especially to the organizing team who really did the week-to-week work building this. Great, thank you again. So we're going to dive right in. And at this point, I would like to introduce our distinguished panel this evening. Leslie Cooper from the ACLU, Curry Cook from Lambda Legal, Julie Cruz from Family Equality, and Dina Scher from Americans United for the Separation of Church and State. Welcome, everybody. Thank you for being this gigantic brain trust on the screen, which means I get to sit here in awe and listen to the amazing analysis that you're going to be providing for folks. I'm not going to talk anymore. I'm going to turn it over to you because we already talked about letting you share everything that you know so far about this. And I think we're going to start with Leslie at the ACLU to kind of set the stage as far as what happened today. And maybe, Leslie, just for folks who aren't familiar, maybe just a 30-second, what is the Fulton case? And then we're going to dive into what happened today.
You bet. Thanks, Brian. Hi, everyone. Great to be here. So the Fulton case, for those who aren't familiar with the facts or who could use a refresher, it's a case that involves a dispute between the city of Philadelphia and an organization called Catholic Social Services, which contracts with the city to provide a variety of foster care services to children in the city's custody. And one of those services, up until 2018, had been screening foster parents for eligibility. It came to the city's attention in 2018 that the agency was unwilling to accept prospective families headed by same-sex couples. And the city informed the agency that that violated the city's non-discrimination policy, and that if they were not willing to comply with that requirement to accept all qualified families and not discriminate, that they wouldn't be able to continue that part of their contracted services. The city was greeted with a lawsuit filed by Catholic Social Services claiming that a constitutional right to get the government's funding, taxpayer funds, to provide this government service, but to opt out of the non-discrimination requirement that applied to all other foster care agencies. That case, started out at the district court, where the court, after a 4-day evidentiary hearing, denied a request for a preliminary injunction, an initial order that the agency sought to have the city renew their contract over their objection to doing so. And again, at the court rejected that, and the Court of Appeals unanimously affirmed, and Supreme Court granted review and took the case. And we held argument back in November, and today we got our decision. And the claims in the case were free exercise of religion and free speech. They said that it violates their religious beliefs to have to certify families to whom they have a religious objection based on their religious beliefs about marriage, and it violates the right to free speech to have to endorse a couple's suitability against their religious objection. We were very concerned when the Supreme Court took this case. I'm sure everyone here felt the same way, given what the court is like these days. And we knew there were a lot of different ways the court could rule, ranging from a win to affirm the decision below, to different types of losses that could be nothing short of catastrophic for the ability to enforce civil rights laws. Because the primary argument being made by the agency was that because they have a religious objection to complying with a non-discrimination requirement, the Constitution, the right to free exercise of religion, gives them a right to opt out of that requirement. And what was so extraordinary about the context is that it's the context of government-funded government services. This is not, folks may remember the Masterpiece Cake Shop case from a few years ago. This is not a private business that wants to discriminate in violation of state public accommodations law. This was an organization wants taxpayer money to provide a government service and then disregard the contract requirements not to discriminate. So quite an extreme context. Nevertheless, given the court we were quite worried that if they accepted that argument in this context, that would be potentially have huge implications, discrimination laws for LGBT people and possibly all non-discrimination protections. So fast forward to June 17th, 2021, and we got our decision today, and first thing that we saw was that it was a decision by Chief Justice Roberts. In the past, that would not be something to celebrate, but now it was. And the decision was unanimous, which was also a surprise. And the decision ruled for Catholic Social Services, but they did it in a way that did not have those catastrophic consequences we feared. The court ruled that the city officials' decision not to renew the agency's contract was impermissible because the city's contract had a provision for offering individual discretionary exceptions to agencies, exceptions to the non-discrimination requirement, which the court held the city could not refuse to extend to Catholic Social Services. In other words, they said because the city's contract allowed these exceptions or had this mechanism for exceptions, even though there was no indication any had been granted, but because there was a mechanism for the commissioner to, in her discretion, grant exceptions, it was not considered, to use the legal terms in the court's jurisprudence, generally applicable, and therefore a very high level of scrutiny had to be applied to that decision to deny the exemption. Strict scrutiny is in the court's parlance. And the court said that there's no compelling reason, which is what the strict scrutiny standard asks for the city to deny the exception to CSS while making it available to others. So they said, basically, this was not an even-handed thing. You have a mechanism in your contract to say exceptions can be granted, but you're not allowing it for this agency. And therefore, it violates the free exercise rights of the agency. This is an extremely narrow ruling based on the unique language of the Philadelphia foster care contract. The court, importantly, declined to establish a constitutional right to discriminate based on your religious beliefs. Just like the Masterpiece Cake Shop decision 4 years ago concerning discrimination by a baker who had a religious objection to serving same-sex couples, the court's ruling is specific to the facts of this particular case and the contract used by the city and does not establish a free exercise exemption from non-discrimination laws. Importantly, very importantly. We know those who are opposed to LGBTQ equality have long sought a First Amendment license to discriminate. This has been part of the strategy since marriage equality really started taking hold a while back. So this has been part of their strategy, a First Amendment license to discriminate. That has been a long-standing goal of our opponents. They didn't get it in Masterpiece Cake Shop, and they didn't get it today in Fulton. Again, in both cases, instead, the court reached very narrow, fact-specific decisions that leave non-discrimination laws and policies in place and fully enforceable. In fact, in the decision today, the court recognized that the city's interest in enforcing non-discrimination protections for same-sex couples was, quote, a weighty one. Folks who've been following the case may also be wondering about another aspect, which is the Catholic Social Services petition had asked the Supreme Court to really overrule the long-standing free exercise standard that the court applies and has applied for 30 plus years. They did not do that. Had they done that and established the kind of standard that Catholic Social Services had asked for, not just non-discrimination laws, but any law that someone felt incidentally burdened their religious beliefs, the government would be put to a very high burden to justify enforcing any kind of law against anyone who said they have a religious objection to complying. So that did not happen today.
Yeah,
yeah.
Oh, I'd say I think that's so important for people to hear, because I know that I've been reading some online articles and seeing some TV shows or news broadcasts, and sometimes there's just a desire to get people to watch it. But it really took me listening to what you were saying here and what some of our other partners were saying to really, even working on this case, realize that this was really not any kind of a loss. In fact, one of our partners, I wanted to read this quote from them, it's from Center for American Progress. It's important, however, to recognize that the Supreme Court could have gone further in its ruling and did not. So they could have, and they chose not to. They didn't, like you said, they didn't recognize, that broad license. So I think it's really great, hopefully, for folks to hear that and internalize that, what you're saying. And I think that that's really great.
Absolutely. They could have gone a lot further. They could have done, we had envisioned a number of different potential scenarios that were very concerning, including scenarios that would have implications for foster care programs across the country, or scenarios that would have implications for a broader range of social service programs, government-funded social service programs, all the way up to implications for all kinds of non-discrimination laws, again, employment, housing, public accommodation, and everything. So it's great news for LGBTQ people and for everyone who depends on the protections of non-discrimination laws that the court issued the narrowest possible ruling. The fact that it was unanimous, I think when we saw that, we didn't expect it was going to be the catastrophe ruling. This is where they landed with this very narrow ruling that is a win for Catholic Social Services, but does not create that license to discriminate that our opponents have long sought. Also, it's great news for the more than 400,000 children in foster care across the country, because the decision will not affect any foster care programs that do not have that unique kind of individualized exemption language in the contracts that give discretion to give exemptions from non-discrimination requirements. And we all know, children are the ones who get hurt when agencies make placement based on their religious beliefs rather than the children's best interest. So this decision allows other foster care programs to continue ensuring that all qualified families can be welcome to meet the needs of children. And the decision, again, as I mentioned, touched on before, it doesn't open the door to discrimination in other government-funded social service programs like homeless shelters or disaster relief programs or healthcare. And it absolutely does not allow for discrimination in the full range of civil rights contexts that we depend on. After today's decision, federal, state, and local governments remain just as able to and should continue to pass and enforce comprehensive non-discrimination laws. Of course, we believe this is critical given the high rates of discrimination experienced by the LGBT community, particularly Black and brown trans women. But I do want to say, just before wrapping up, even though I may seem very happy about the result today, in the sense that although it is a loss, it is a very limited loss. I recognize that it can be very painful to the community to have a loss, even if it's a narrow one. But like I said, we've been bracing for the possibility of something very damaging that would have potentially really prevented governments from enforcing a whole range of non-discrimination protection laws, perhaps just for LGBTQ people, perhaps for everyone, when the discrimination is motivated by religious beliefs. So today's decision is absolutely a relief, because our opponents have once again failed to achieve that result. Thanks.
And I think this is Dina Scher from Americans United. Just to sort of build on what Leslie was saying, I think it's quite telling that if you read the concurrence by Justice Barrett and Justice Kavanaugh signed onto it, in the past, they have expressed concern and interest in overturning that standard and which Leslie talked about, and we fear would lead to the worst possible outcomes. But Justice Barrett wrote a decision that said, gosh, I don't think we can go that far. Like, if we overturn this case, we really need to be careful, because there are some pretty severe consequences that are going to come from it. She didn't have any answers, but she raised really important questions, so that if this question comes before the court again, people are going to have to really work hard to get their buy-in in changing, making a decision otherwise.
I just want to add to that. This is Julie Cruiser with Family Equality. I'm the non-attorney on the panel. And what struck me in this decision is that LGBTQ foster youth were invisible in this decision. And I listened to the arguments and they seemed invisible there. And I find that shocking, because 1 in 3 foster youth identify as LGBTQ. They have really poor outcomes in care. And they don't get to choose what agency they work with. So I don't know if any of the attorneys want to address that from a legal aspect, but it just seemed to me, why was the Supreme Court not talking about the most vulnerable children and what's best for them? And maybe that's not a legal question, but it's just one that I think we should all keep in mind as we talk about this, and remember those kids, and remember those LGBTQ kids in Philadelphia that are hurting right now, and send them our love and support.
Yeah, thank you, Julie. I can jump in on that point. My name's Curry Cook. I use he, him, his pronouns, and I'm an attorney with Lambda Legal and direct Lambda's Youth and Out-of-Home Care Project. And I come to this work at Lambda from prior representation of young people in foster care in Alaska and New Jersey and New York, and have just seen firsthand representing clients over the years exactly Julie's point. Really treating them as invisible, and almost another version of don't ask, don't tell. Like, we're just going to pretend you're not here and go about our business. And, unfortunately, we did see that in the context of the Supreme Court, although many of our organizations, lifted up the overrepresentation of LGBTQ in care, their poor outcomes, and that really any kind of policy that permits agencies to exclude people on criteria that are completely unrelated to their ability to be parents, like who they are, who they love, what they believe or don't, limits the options for kids in foster care. And while we have a long way to go with the child welfare system in general, because it is built on systemic racism and poverty, and as Leslie pointed out earlier, funnels Black and brown children into the system, in addition to LGBT youth and Black and brown LGBTQ youth. So there's much work to be done to completely abolish or undo or reform the system, and many people are working on that. In the meantime, we have a system, as Julie mentioned, that has about a third of the children in it, according to some studies, that are LGBTQ. And they disproportionately end up in group homes and then exit foster care to homelessness. All the while being exposed to criminalization, justice involvement while in care, and especially if they exit care, to homelessness. We know that LGBT foster and adoptive parents have been an underutilized resource nationwide and have had a history of having to navigate discriminatory policies, inappropriate questions, pretending that their person that they love or have been in a years-long relationship with is their roommate. For licensing purposes. These have all been the things that folks have had to navigate for years. And, building off Leslie's point about the ability of state and local governments to, continue to pursue non-discrimination policies, I think it's essential for all of us to really continue that work and double down, because we're in 2021. And by our count, only about half of the states, or a little over, have sexual orientation and gender identity protections as they apply to young people. and fewer that clearly apply to families of origin and foster and adopted parents. And we have much work to do. The good news is there are a lot of wonderful people doing this work and pushing this, and we're making progress every day. And that includes in places that may be very conservative politically, in the governor's office or legislative branch. People that work with children in this field are doing the work. And significantly, we have young people who are LGBTQ plus, who have lived experience in the system, who are now really engaged in systemic reform and training and sharing their stories and just being out and demanding change and no longer being invisible or silent. So I think we can really take this and take the exposure both to the public at large and to our community about LGBTQ youth in care, the foster care system in general, and doubling down on having all of the LGBTQ foster and adoptive parents and anyone who has been excluded, to demand to be involved and be treated fairly. So I'll stop there because I know we have a lot of other topics to cover, but I'll turn it back over to Brian with additional questions.
There we go. Thank you. And Julie, it's so funny because you and I work so closely together, and I'm always learning new things about the foster system, the adoption system. And you're right, this ruling just completely ignored these kids. Like, it was all about, this idea of, did the contract have this word or that word in it? And what was interesting to me is that, you talk to anybody that's working in the system and what they want and the way that they try to design everything, what's the best for the kids? Like, what is the best thing for these youth? And, that wasn't, that didn't seem to be asked. I think one of the questions, and I'm actually going to pull this inspired by one of the folks here in the live stream, is what can an organization like Philadelphia or other cities and municipalities who contract out some of their foster and adoptive, what can they do to ensure that kids are being placed in the best homes possible and not be open to what happened to Philadelphia? How can they, do they even need to? Is this really like a very specific thing for Philadelphia?
Well, I'd like to answer that.
Go ahead.
I'd like to answer that on the federal level, and then I know Curry has a lot of experience in the state level. It looks like Leslie has some thoughts as well. And I just want to encourage folks. Curry and I and many other groups founded the Every Child Deserves a Family campaign 3 years ago, precisely because, as a foster alumni who spoke at the rally we just held said to me once, that the culture wars are being fought on the backs of children, and we needed to reframe this because, as Leslie said, in child welfare there's one cardinal rule, which is you must act in the best interest of the child. And when you're talking about the personal beliefs of people who work at agencies, you've really gotten pretty far away from that. So we founded the Every Child Deserves a Family campaign at everychilddeservesafamily.com, which now has over 700 members, free to join. Please join us, and you can either join Curry's state policy group or the national policy group that I co-lead with allies. And on the federal level, one of the policy changes we're seeking to enact is the John Lewis Every Child Deserves a Family Act, which would once and for all nationwide ban the most rampant discrimination that's still allowed in child welfare, which is against LGBTQ people, single people, and religious minorities. Because, of course, discrimination against racial minorities is barred under the Civil Rights Act of 1964. And but 2 years ago, John Lewis, who was the bill lead, decided he really wanted this bill to be transformative, to not just bar discrimination, which is really the floor that we have to build from in order to improve care for LGBTQ youth. And so he rewrote the bill to include technical assistance and training for everyone in the foster care system, from judges to caseworkers to foster parents, on how to improve care for LGBTQ youth, and to stand up a research center at HHS to improve this care and improve outcomes. and to collect data on LGBTQ foster youth and families so we're not invisible anymore. And frankly, most of those steps are steps that the Department of Health and Human Services could take right now. So one of the things we'd like to see is for Congress to pass the John Lewis Every Child Deserves a Family Act, for Congress to pass the Equality Act to extend non-discrimination to every program and many, many aspects of all of our lives. But also for HHS to start taking action right now to do some of these things that will improve care. This is one of 3 kids in foster care. You're not going to fix foster care when you have disastrous outcomes for 1/3 of the kids in care.
Great, thank you so much. I'm going to go to, as you can see scrolling on the bottom, if you have a question, you can text that there to 727-266-5667. We'll try to get to those. For those that are able to chat on YouTube, we'll try to pull some from there as well. What is the legal strategy that the LGBTQ community can lead to actively protect our community from the efforts of those that want to use religious liberty to justify discrimination? And I would maybe add that it's not just the LGBTQ community that is in danger of the misuse of religious liberty to justify discrimination, but hand it over to you all.
I do have a couple of thoughts on that, and absolutely a really important point that it's not just the LGBTQ community that is at risk of discrimination if there's a religious right to discriminate. And we know, even in the foster care context, that there are agencies that are excluding families because they're the wrong faith. And that's, in a lot of states in the country. And so, yes, if there is a constitutional right to opt out of non-discrimination requirements that conflict with your faith or that you have religious objection to complying with, that puts all of us at risk. But in terms of what we can do, I do want to just say, in terms of dealing with the problem of expansion of religious exemptions to gut non-discrimination protections, I think one of the things that happened in this case that I think made a big difference and it contributed to preventing that kind of outcome was the extraordinary array of amicus briefs, friend of the court briefs, that were submitted by a range of civil rights groups, every major child welfare group, child welfare professionals who are responsible for children in foster care, faith communities, huge numbers of faith leaders on the concern about implications for communities of faith, for example, and many others. And I think educating the court and, when we try to do the same with the public about the implications and harms that happen when you establish a license to discriminate, I think that gave them pause. I think that, they granted cert, they granted review in this case. I think there was, it was the second time they took a case like this, and I think both in Masterpiece and here, it was likely for at least a number of members of the court with the intention of establishing that kind of right. But I think seeing the implications and how extraordinary they are, how far-reaching they are, I think may have had a real impact. So I think convincing the public through these same diverse voices about how discrimination hurts people, whether it's motivated by religious beliefs or something else, it hurts and harms people in lots of ways. I think that can make a huge difference.
And like Julie, I think there is also, there's sort of a parallel track. This was about the Constitution, and thankfully it came out the way it did. But there's a federal law called the Religious Freedom Restoration Act that was passed with good intentions and was designed mostly to protect religious minorities, but has been used to foster discrimination. It was the basis of the Hobby Lobby case that many of you probably remember. Preserve the law's power to protect religious freedom and clarify that it may not be used to harm others. So RFRA is really important in some contexts. For instance, when sick people serve in the military, they can use RFRA to allow them to do so while wearing a head covering or having an unshorn beard, or in the federal prisons or immigration detention. It allows people who are detained to ask to make sure that they can go to religious services. So it obviously does really good and important things, but as we saw in Hobby Lobby, it's used to undermine really important protections we have in federal law. So the Do No Harm Act would ensure that RFRA can't be used to undermine non-discrimination laws or laws that guarantee access to healthcare or child labor laws, or federal programs designed to help people, like in the foster care situation, or even like programs that fund homeless shelters. So that's another response that will help us ensure and sort of make sure that religious freedom is a shield that protects us all and not a sword to harm others.
Great, thanks. We're going to bring up one of the questions from the chat. Great. Bob says, should we in Philadelphia be lobbying City Hall to change that loophole?
Yeah, that's a great question, and I'm not sure it's City Hall. It's and I understand the word why you use the word loophole, but to give a little context, that might be helpful. The court's ruling turned on that contract provision, right? That says that there can be exemptions given to the non-discrimination provision at the sole discretion of the commissioner. And they said the existence of that mechanism by itself means that the policy is not generally applicable. Now, the district court found that not a single exemption actually had been granted to agencies that screen foster parents. And there's no indication the city ever intended to allow exemptions, because it was a provision that had a few different meanings to it, didn't just apply to screening of foster parents. And there were other contexts in which exemptions could make sense potentially in other contexts. So, I think whether it's Philadelphia or any other foster care program, to the extent they do not intend to allow exemptions from the non-discrimination requirement for agencies that screen foster parents, and there really is no reason you would want an exemption from for agencies screening foster parents, they should be really careful what their contracts say and take a look and make sure there's nothing in there they didn't mean to have in there. And so in Philadelphia, I know that it's a City Hall, but the Department of Human Services, that would control the program. But I would leave it to the city of Philadelphia, to the lawyers for the city to speak to that, whether they think that would be helpful or not. I know we don't have them here with us today, but I don't feel like I can speak to that directly.
Great. Thank you. And we've got a second question also from the chat. How is this not any different from the Scoop Kids, where Indigenous children were placed with non-Indigenous families and not allowed to learn about and practice their heritage?
I don't want to take up too much time here, but I'm glad you raised this question, because there was a very powerful amicus brief that was submitted in the case by scholars of Native American law, focusing very much on the fear that the prospect of allowing agencies to disregard non-discrimination requirements to practice child welfare practice in accordance with their faith, that causes fear in the Native American community, who knows that shameful history of children being taken from their families, often by religious organizations, to be sort of indoctrinated in Christian white families, as considered the appropriate education or upbringing for a child. So, what's different here? I mean, that was obviously a horrible time in our history that we're still overcoming with the Indian child welfare act. But one thing, Curry will probably and Julie could probably say much more about this. But the foster care programs vary in how they operate from state to state and city to city, and in here, at least, Catholic Social Services' role at issue in the case was solely screening foster families for suitability. The question of, where you place a child, it was not at issue in the case. However, that is an issue in other places, and we had litigated a case in Michigan where the agencies that contract with the government make the placement decisions for children. So you precisely have a very, I don't want to make comparisons, but you have a situation where agencies are choosing families for children based on religious criteria. And there was a situation in Michigan where an agency separated a child from his siblings because the siblings were the same-sex couple and they had a religious objection to placing children with same-sex parent families. Like, that should never, ever happen. So absolutely, it is if this kind of a claimed right to discriminate in the foster care system and it goes into the placement practices in particular, that could really have additional negative impacts on children apart from denying them access to a pool of qualified families. But I know Curry and others probably have more to say about that.
Yeah, I'll just add that, I mean, what Leslie is pointing out is a major concern, because as the child welfare system has moved to what some call more of a privatization model, like more and more agencies are doing just that, like are the ones that are in charge of placement decisions. So this concern that Leslie mentioned is real in terms of being able to have those decisions. And as we move more towards a prevention model, thankfully, which is fantastic, that also means that agencies may well be working with families outside of the purview of the court and parents and children without lawyers or advocates. So just being mindful of that role that agencies play is really, really important. And also, I would just note that this history of discrimination that Leslie alluded to is still alive and well. We have a case facing foster care in Alaska v. HHS, which was a challenge to the last minute, one of the midnight regs that came out from the Trump administration, which was to try to gut the protections in the HHS grants rule and pull out protections against discrimination on the basis of sex, religion, sexual orientation, and gender identity from the 2016 Obama era grants rule. And that actually would be the only federal level protection in the absence of the Equality Act and Every Child Deserves a Family Act, as HHS dollars flow down in grants to the child welfare system and the states. And in that case, facing foster care in Alaska through affidavits from their executive director and one of their members, a trans Alaska Native young woman in care, talked about the challenges that their members face in care who are Alaska Native and are trying to practice their cultural traditions and their religion, and also navigate being LGBTQ simultaneously together, separately for their members who are Alaska Native and not LGBTQ, but really have trouble making sure that they, as children in care, that their rights to religious freedom and to practice or not practice the religion of their choice are encouraged. So I think, as we've seen in the case Leslie and I are working on, when foster care agencies are saying their foster parents are there to be in a place of spiritual influence, what does that mean, and where does that leave the rights of kids in care who, as we've articulated, should be paramount, their needs and their rights, not the rights of people that are there to provide them care. So, thank you for raising that, Robert, because I think it's really important, and also kind of gets at this issue, I think, of intersectionality in the system and faith as it interplays with LGBTQ identity, and thinking about, again, the children and families who are in the case, and why that we should be prioritizing them and not providers' interests always.
And I just wanted to speak to one more aspect of that, which is the removal aspect. And what Curry was alluding to before, that there's a very racist history to child welfare in this country, with the and policies around children, taking away children of slaves, removing children from tribal reservations and then sending them somewhere where they would be, quote unquote better off, all the way up to separating children from their families at the border. And we still see that tribal families are 4 times more likely to have their children removed. And there was just a study that lesbian and bisexual women are 4 times more likely to have our children removed than our heterosexual counterparts. So it is very scary when you think of a religious right to discriminate, because then folks are thinking about, well, who do I think should be a parent? And if they have removal decisions to say these people don't constitute a good family, this is why these non-discrimination protections are so important as well, is to protect families of origin, protect kin, protect siblings, just every aspect of the system that's critical.
Thank you. Yeah, because as you were talking, this kind of privatization, whether it be privatization of foster care, privatization of homeless shelters, privatization of these things that would traditionally be a government service. If you walked into the DMV and the DMV said, I'm not going to serve you because you're X, Y, or Z, people would be up in arms about it. But if you privatized, or you hired a third party to run a couple DMV offices, say in rural areas or someplace where it's difficult to reach, that's really what we're talking about here, is that should they have to, since they're providing the government service, at the government's discretion and contract, treat you the way that another would. And I think I think most people would agree that is the way it should be. So, it's interesting to see that there's, that just where people's arguments come from. We did have another question that got texted in. Dina, I'd love to hear your thoughts on this to start, and then we could bebop it around. Is there language in the court's decision that could be problematic in future cases? And I would say not just, maybe LGBT rights cases, but also just, cases where, as we mentioned earlier, this kind of abuse of religious liberty as an excuse for discrimination or taking away or denying rights to groups of people, women or otherwise.
Sure. Yeah, there's when it comes to religious liberty, there's always the other side of the coin. It was a very, as positive a decision as we could have expected, but 5 justices said they were interested in revisiting that protection that exists in the Constitution now that says the First Amendment is not a license to discriminate. And so, we just have to watch. We know that the other side is going to continue this. They've tried this, as Leslie mentioned, this is the second time in 4 years, and these cases aren't going away. So we're going to be back, unfortunately, in this situation again in the future. But the more that we can build support for these laws in Congress and in the states, and the more we can create the general understanding in the public that religious freedom is not a license to discriminate, I think, we are going to be in a better position every single time it happens.
We'll start with unmuting. That's always helpful. Does anybody else want to add on to that, or I can move on to the next question?
I could just say one thing. This didn't go to the court's ruling or holding in the case, but there was a passage where the opinion just accepted the other side's assertion that the city's interest in maximizing their pool of families was not furthered by enforcing the non-discrimination rule against this agency, and in fact, that it could reduce the number of families by this agency closing. The court just said it in the opinion. It didn't have any support for it. There was certainly no support for it in the record. In fact, the record at the district court below, the court found just the opposite, that Catholic Social Services ceasing foster care screening work did not have any impact on the number of families, but they just kind of put it out there. So that was disappointing that they just accepted that. And it was surprising because there were many briefs by the child welfare professional organizations that could not have been clearer that there is no basis for this assertion that really I view the most counterintuitive assertion that the way to get more families is to allow agencies to discriminate against qualified families, right? That if you lose these agencies, they say you're going to have fewer families, as if the problem were a shortage of agencies, when in fact the problem is the shortage of families, not agencies. So that was disappointing to see there. It was not, again, relevant. It wasn't part of the legal conclusion, but it's just out there, and that was disappointing.
I kind of building on that, I think that it's not one of the disappointing things, but I think interesting things, that the kind of compromise that they worked out in this case only works in a city, right? Where there are a lot of agencies. If you move this decision to rural Texas or rural Nebraska, it doesn't work. And I don't think that they can, I think that's a good sign, right? Like there's no way that they can say, oh, the pool of, there's plenty of other providers out there. So I don't know. I don't know what you think about that, Leslie and Curry and Julie, but that struck me today, is that it's not a one size fits all. It is beyond specific to Philadelphia.
Well, I think, yeah, they implicate, oh, go ahead, Curry.
No, go ahead. I'll go after you.
Yeah, I was gonna say the implications, if you had the exact same facts with the exact same contract provision, and but that was the only agency for miles and miles and miles, I don't know what the decision would have looked like if that was the situation we were in, but certainly the implications would be very different. We think the implications are pretty, I know you agree, pretty serious. Either way, when you allow any agencies to discriminate, even when there are others, because being turned away by an agency is, you can't count on that person to then go and keep knocking on doors, not knowing if they will face discrimination again, and we lose families and can lose families. But certainly if it compounds that problem when you don't have other agencies to go to, for sure.
Right, and also, even though, we're very glad that this wasn't completely horrible today, it still does leave the situation in Philly being that, if you're a couple who's a different sex couple and you're married, then you have every agency that you can choose from to meet your needs. And if you're a same-sex couple that's married, you don't. There are some that you can go to, so that's sort of the definition of inequality. And I think important to recognize that even when there are multiple agencies, you shouldn't have to just go to the ones that will take you. You should be able to decide which one is a good fit for you around things that aren't related to your ability to parent, right, or somebody else's perception of your ability to be a suitable parent. So just wanted to note that while we're happy that it wasn't worse.
And I would just add again what young people are always telling us, and I know Curry hears it all the time too, but kids don't get to pick agencies, and kids are smart. It was interesting to me, Chapin Hall did a study on homelessness, and one of their primary recommendations for reducing youth homelessness was make sure that agencies and communities of color are LGBTQ affirming, because so many kids actually become homeless by choosing to walk away from agencies that are not affirming of them, and choosing homelessness and living on the streets over foster care. So those things trickle down. I mean, the evidence is there that when agencies discriminate, it's bad for kids, it's bad for their health. That's been really well documented.
Right, and even though it should be counterintuitive, just by virtue of being in foster care, for any kid, you have a higher rate of experiencing homelessness later, higher rate of justice involvement, and layer on LGBTQ identity and race, those stats are sort of on steroids, right? And so it creates these other pipelines into the justice system that we already know affect LGBTQ people disproportionately. So I think that's another reason why, we really do need to see a doubling down and focus on the foster care system for our community, because it is unfortunately a feeder into such bad outcomes. And, as we talked about, some, recenter our efforts and making sure that we have programs in communities that can promote family and community acceptance for youth. So hopefully they can safely be home with their families, because we know those work. They just don't exist in enough places, and we need more of them. And then for those kids who can't successfully be home they need more options to expand the pool, as we've talked about a bunch today. And I'll add one more thing that we haven't talked about yet, but we should before we go. And then I think we have another couple of questions. It's just this whole question of data. Like, we've talked a little bit about overrepresentation of LGBTQ youth in care and underutilized LGBTQ foster and adopted parents. But the reason we know some of this is from a few studies that have been done, a couple funded by the federal government. But we actually don't have nationwide data about the numbers of LGBTQ in care or LGBTQ foster and adopted parents or parents. Some of you may know, who've been following along in the child welfare world the last 4 or 5 years, that at the end of the Obama administration, they did put out a rule, the AFCARS rule, Adoption and Foster Care Analysis and Reporting System, and ask agencies, required agencies, to collect sexual orientation identity information from youth 14 and over, and from foster and adopted parents and legal guardians, voluntarily disclose, but the agency would have to ask, and a whole host of other elements, including important ones related to implementation of the Indian Child Welfare Act. The Trump administration issued a new rule, pulled the sexual orientation requirements, a whole bunch of other ones, including many of the ICWA-related items. So we were at a point where we could have been, the last 4 years, collecting this information, so we have information about who's in the system and, most importantly, what their outcomes are, being able to compare those to race, being able to compare those to youth who've experienced trafficking, like all these important cross-references in the data points, but we haven't. And that rule is still out there. We have a lawsuit challenging it, but it has not been resolved yet. And we really hope that this administration will step up and implement a new rule and begin to collect that data, so we actually have some information nationwide about experiences of LGBTQ youth and families.
Great, thanks. And then I know we have another question over here in the chat, so I think Liz is going to bring it up for us. So can biological families of foster kids decide they do not want their child who is in foster care to be housed with the same-sex couple or any other couple, religion, race, otherwise, that they might object to?
I'll jump in briefly. I have definitely seen parents, and just cases that I've been involved in over the years, express concern, or that they didn't want their child to be placed with the same-sex couple. In my experience, generally, child welfare agencies preserve their ability to decide, where placement is made, while also doing their best to work cooperatively with parents about their wishes and desires. But typically, if they feel like the parents are, that is motivated by some sort of discrimination on their part, they typically don't accommodate that. That said, there are, efforts to make sure that if parents want to make sure that their child, for example, is in a home where they can practice their faith, that agencies will try to accommodate that. So I think there's a balancing line between making sure that, you're working cooperatively with parents of children, but also making sure that, they're not engaging in discrimination themselves when this placement may otherwise be in the best interest of the child. A lot to navigate there, so I don't want to oversimplify it, but folks, jump in if you have anything else to add.
Yeah, I would just add, I've just heard it, probably not frequently, but one of the things that the agencies will be thinking about for the child is their reunification with their parents. And so, I have heard anecdotally in cases where caseworkers made the judgment that if the child is placed with a same-sex couple, when the parents have, for whatever reason, religious or otherwise, a strong objection, and it would hamper the ability for them to work in partnership towards reunification in a system where that happens, that's been considered. But ultimately, the caseworkers are meant to be making the decisions based on the best interest of the child. But parents' wishes to the extent they, affect the interests of the child, are definitely are appropriately to consider. But I think I have not heard of many cases where that has happened in this particular concern.
So I'd like to wrap up with one more question before we share a little bit of information with folks, little action. In what other venues do each of you believe that Catholic social services or other religiously affiliated social service agencies or other religious groups will fight for the right to discriminate? Where do we see, maybe we're already seeing the fights happening, but they're just kind of growing. But obviously this case was foster care. Where else do we see this happening or the potential to happen or growing?
This is Dina from Americans United. I think anytime there are social services funded by the government and they partner with faith-based organizations, and they're required to provide services that might conflict with their religious beliefs, either because of the people who are served or the type of services provided, we're going to see that conflict. So if there's reproductive health care that has to be provided under a program, for instance, serving unaccompanied minors, they have to provide reproductive health care to the unaccompanied minors. And we've seen some of the government contractors try to object to those services. So it's the range of services the government funds is sort of extraordinary. It's hard to wrap your head around it. And so we know that this could come up almost anywhere. And it's also possible that, they would claim a right to kind of proselytize within the program, right? So that's like a bright line. You cannot have religious content in a program. But if you say that you have a religious right to violate that rule, then, a different administration, a different time, a different place, a different government may say, okay, yeah, you have a religious right to do it. It's so it could be wide ranging and a little bit frightening, a lot frightening.
Yeah, I would just add, there are two cases with petitions for review pending at the Supreme Court involving conflicts. One in the context of healthcare for transition-related healthcare for a transgender man with a religious affiliated hospital had an objection to allowing the treatment to happen there. And another is another wedding vendor case, a florist case very similar to the Masterpiece Cake Shop case. And there are many other wedding vendor cases percolating up. So I would agree, these are happening, and there will be more.
Yeah, one area that I'll mention where this plays out and the intersection of these two areas of service provision are for survivors of trafficking, and then also those folks who are accessing services when they're experiencing homelessness. So one of the plaintiffs in the AFCAR's case and another case we have Mazan with Americans United and Democracy Forward, Arc of Freedom Alliance serves LGBTQ plus survivors of trafficking in South Florida, and had members who, like, their only option for someplace to go to receive housing was the faith-based providers with Bibles on the nightstand and religious messaging, and they opted just to sleep on the streets and, in a dumpster, one of them, for a night, because that was not someplace that they felt safe going. So, to Dina's point, where the intersection of, service provision through grants or contracts for government services for housing, trafficking, that's a place where there are faith-based providers. Now, granted, there are wonderful faith-based providers who are really affirming to LGBTQ people in all of these areas too, but this is a place where there's a lot of government contracting and granting going on.
Brian, before we wrap, I would just like to do a quick shout out, if that's all right.
Yes, but before you do a quick shout out, because of course we always have a little bit more, I think Curry had a really quick question that he wanted to answer, and then Julie, I want to pass it over to you.
Well, I'll actually take over your role for a second, Brian. Just pose a question to the panel that I received from an attorney I know watching via email, coming in from all sources this evening about the public accommodations portion of the decision today. And so I guess maybe I'll turn to Leslie to start her thoughts on what the Supreme Court had to say about foster care as a public accommodation in the opinion.
Yeah. Okay. So just to give folks, I'm glad you brought that up. To give folks context, after talking about the provision that that the court ultimately relied on to say that the policy was not generally applicable because it allows for discretionary exemptions, the court responded to the city's argument that, well, there's also the local non-discrimination ordinance that applies to foster care agencies. We can't give exemptions because the city ordinance doesn't permit it. And this was really interesting to see the Supreme Court engaging in local ordinance statutory interpretation and disregarding the interpretation of the federal district court and also the Third Circuit that interpreted the language of the public accommodations ordinance as applying to foster care agencies. And the court accepted the other side's argument that no, they could never be public accommodations because, you know, there's foster care is selective in terms of eligibility. You have to meet all these criteria. It's not open to everybody like a hotel or a restaurant. I think that the analysis made no sense because, you know, of course you have to meet the requirements. You know, you can go to a mortgager to get a mortgage, and if you don't meet the requirements, you can be turned away, and that doesn't mean it's not a public accommodation. Here, you have to meet the requirements to be a foster parent, and there's selectivity about ability to care for a child, but to turn someone away based on a protected characteristic, I mean, to me, it's a public accommodation under the Philadelphia ordinance language. Now, all the different cities and states have different public accommodation language, and so it's not necessarily, you know, saying that every public accommodation ordinance around the country does not apply to foster care, but it was pretty broad stroke kind of analysis that should give pause to for anyone relying on public accommodations laws to ensure non-discrimination protections in the foster care system. It was, you know, with respect, sloppy. and again, I don't think the analysis was right, but it's there. And so it is something we should be paying attention to. I think in most places where there are non-discrimination protections, Curry's going to tell me I'm getting this wrong maybe, but you know, there are statutes and that are not public accommodation statutes, but child welfare statutes that have the non-discrimination provision, or regulations that are child welfare regulations, and not necessarily relying on public accommodation laws. But where folks are viewing the public accommodation laws as the non-discrimination protection, I think that just needs to be looked at.
Yeah, and I'll just add that there are many public accommodations laws at the state and local level that do explicitly include in public accommodations government services or government funded services, which is clearly, in the wake of this, we knew this before, but even more clear now, like the gold standard, you know, in terms of clarity. So I'll just add that it, you know, it is very dependent on the language, you know, as Leslie pointed out.
And Curry and Leslie, does the Equality Act provide some of that clarity? Would that help passage of the Equality Act make that clear?
Well, clearly we need to pass the Equality Act, right, urgently. And of course does clarify within it that all government funded services, you're protected when you're accessing those and you can't be discriminated against. It does include those important protected classes I mentioned a little bit ago, sex, sexual orientation, gender identity that don't appear in federal civil rights law that applies to child welfare, or in underlying child welfare federal statutes in particular, since we're talking about foster care. But yes, I think, you know, that'd be a really important addition at the federal level. So call your senators.
Julie, I want to turn it back over to you.
I just wanted to really, on behalf of the families that Family Equality represents, really thank the interveners in this case. We'll really thank the city of Philadelphia for standing up for their residents. But if you weren't seen and heard, your city might not stand up for you in the same way. So big thanks to the Support Center for Child Advocates, and especially Philadelphia Family Pride, which is part of our national network of LGBTQ family groups. The fact that you stood up and told your stories, and then of course the ACLU for representing that and lifting up those stories in amicus briefs. I think you were really a model nationwide, and just know that we are thinking of you, Bob, and the other folks on the call from Philadelphia. Our hearts go out to families in Philadelphia, but Philadelphia Family Pride urged me to remind folks that LGBTQ parents are just as good as any other parent. And if you're struggling in Philadelphia to foster and adopt, do get in touch with Philadelphia Family Pride. And to the LGBTQ and Two-Spirit foster youth in Philadelphia, we see you, we love you, we are going to fight for excellent affirming placements for you.
Great. Thank you so much for that, Julie, for that shout out. And so how we would like to wrap up tonight, we've heard a lot about what's going on. And while this wasn't as bad as it could have been, we know we still have a lot of work to do, both on this and in other on other issues for LGBTQ people and families. And one of the things that we need folks to do is we need to pass the Equality Act. And the Equality Act would, for the first time, provide protections for LGBTQ people in all 50 states. It would also improve protections for women and people of color and people of faith. And so right now, what we're asking folks to do, take out your phone. You can scan the QR code and pop open the phone number, or you can just dial the 888 number right there. It'll prompt you to put in your zip code and then give you the option to transfer to your US Senator. It'll tell you what to include in your message, but it's here on the screen as well, your name and address, so they know you live in that state. You want them to support the Equality Act. And if you can share a personal story, even something like I just sat through an amazing webinar and saw why it's so important that LGBTQ people have real federal protections. We encourage you to do that tonight after this. Then just call the number a second time, choose your second senator, and leave the exact same message. But it's something simple and easy you can do, and you can do it every day. You can do it once a week. It does all add up. I want to thank so much Dina from Americans United, and Curry from Lambda Legal, and Leslie from ACLU, and Julie from Family Equality, my friends and partners in this fight, and all of the people that you represent being here from your organizations that I know helped to make today happen and make it possible for you to be here and to share what you know with us. And of course, all of the organizations that are part of Decision Day that have been working tirelessly since February to prepare for this, including waking up early to watch the Supreme Court many, many days leading up to this. So thank you all so much for being here today. To PFLAG for hosting us, Liz behind the scenes who you can't see, but making sure all of this runs smoothly, and our interpreters, Glashonda and Johnny. Thank you all. Have a great night.